Yes, sir.
Okay, I'm going to do this standing up. So this is regarding a motion for mistrial and/or motion for new trial based on inadmissible evidence. And I'm reading the title from the state's objections to regarding a disgruntled juror. And it is defense counsel's motion. So at this time, Mr. Nettles, if you wish to proceed.
Your Honor, on Friday, we were before this court. I guess that would be October 29th, 2021. I had motioned this court for a mistrial. I'd asked this court to set aside that verdict that was, I guess, given by those jurors in light of, all of the events that did happen. I guess that was October 28th, 2021, before this court.
Yes.
Your Honor, I think I know we went through the arguments on Friday, and the state had case law prepared. And Your Honor, I really just think that this argument boils down to Mr. Hiller's Fifth and Sixth Amendment rights, his right to due process before this court when charged with a crime, his right to a fair trial. And I don't think that he got either of those things here. I think that his due process rights were denied. I think that his right to a fair trial was denied. The jurors, Your Honor, clearly something went wrong. And they came out here, announced guilty, yet half of them were at least two of them, when polled, were saying not guilty. They clearly did not understand what they were doing. Obviously, we can't get into some of the specifics that they said when we were back there in the jury room. But at the very least, what is before the court is that they came in here with a verdict of guilty. They swore it was a unanimous verdict, and then it was promptly not a unanimous verdict. Your Honor told them to go back there and to continue deliberating. Your Honor, Mr. Hiller deserves a fair chance. Mr. Hiller deserves a fair trial, and he did not get a fair trial, and his due process rights have been violated. We are asking that the court set aside that verdict, declare a mistrial, and we can do this again.
All right,
Thank you.
Thank you.
May I proceed, Your Honor?
Yes, you may proceed.
Your Honor, the defendant did receive a fair trial, and all of his rights as laid out in the Constitution, both the United States and of Texas, were honored by the process that happened here. The jury, it was unusual that they came in with a verdict, and when they were polled the first time, two of them said not guilty. However, you sent them back to deliberate further. They came back a second time. The verdict was again guilty. And when you polled them the second time, they all said guilty. And the case law, one of the cases we gave you on Friday was United States v. Strach. It's from the Fifth Circuit. And in that case, the court explicitly says that if a jury is polled and all of the jurors affirm the verdict, then it cannot be argued that the verdict is not unanimous. And the entire basis for defense's arguments come from something that happened after the trial was over, after the verdict had been read into the record, after you had discharged the jury. And there are very well-established laws that say that once that process has ended, unless there is evidence of outside influence, that they took into consideration evidence from an outside person or an outside source that was not presented to them through the court, through the trial, unless there's evidence of that, nothing at all can come in regarding jury deliberations. I mean, jury trials are important. It's a jury of a person's peers. It's not a jury of legal experts. And the simple fact is that none of what was said back there can come in and affect the trial, because the trial followed all the rules of law. And we cannot open the door to allowing prosecutors or defense attorneys to go and talk to the jury after a trial, dig into their decision-making, dig into their thought processes. And then if we discover that maybe they didn't perfectly understand the law or follow it perfectly, try to impeach their verdict after the fact. There's just a mountain of well-established law that prohibits that, because jury trials are important and they need to be protected, and the verdicts are final for a reason. So we would ask that the court deny this motion. And if defense may appeal the decision, they have other avenues, but granting a mistrial over something that's completely inadmissible, we're talking about it vaguely, but it's not at all admissible into evidence. Granting a mistrial on that would be inappropriate and not in accord with the law.
Thank you. Well, I'll be honest, I was shocked. I've done many, many jury trials, some that have lasted weeks and weeks, and some that last a day. And when I read that verdict, that it was unanimous, and then defense counsel asked that I poll the jury, I totally expected them to all say that that was their verdict. But that's not what happened. And quite frankly, it makes me a little uneasy, because our charge is very clear. I mean, I don't know how you can say things more clearly than what is contained in the charge, and I've given them instructions. Now, the only thing is, on the civil side, when I had totally unexpected verdicts, it was, well, I'll give you an example. We did a lot of medical malpractice, and we did a lot of science-based trials. And we had a jury come in for about, I want to say 4 or 5 days. And we were all making assumptions. Well, they're going to, vote this way, because if it was the expected verdict from the evidence, they would have been finished the first day or the second day at the very least. But they were stuck on what exactly preponderance of the evidence means. Now, we as lawyers, we hear that all the time. And so to us, it's pretty clear. But lay people sometimes, I think, overthink things. I mean, they're trying to do their best, I think. I don't think that they are, I think it's really a matter of being very conscientious. And so that's the only thing I can think of in this case. But at the same time, it does really concern me that if they're thinking that the standard is beyond a reasonable doubt, some may think, well, what is reasonable and what isn't? I mean, we know from during jury trials on this side that not everybody has the same idea of what reasonable is. So I don't know what was in their heads. I was very impressed by the fact that they took so long to come up with a verdict, because that meant that what we told them, the instructions were important. But like I said, I've never had that happen to me before. So the only concern I really have is imposing my verdict and disregarding the jury's verdict. I just never want to do that, because, during jury trials, I'm just the judge that, makes sure we're following the laws and the rules and evidence. I'm not the judge of the facts. So I have, even though I just looked at the documents as the state gave me very fast. Went over it Friday, but I probably overthink things too, quite frankly, but I like to take my time and really try to see where the truth is. So, and that's why I wasn't really prepared to make any kind of ruling on Friday night. On Friday or Thursday night. Thursday night, I was really tired, so I just didn't think I wanted to make any important decisions that night. And so truthfully, I went in there and I was sort of surprised that I did hear some things about questions they would have had, but they never, they're not questions that we would have heard that were really about I think it was more about credibility or the weight of the evidence. And so, that's not unusual. I know that lawyers go and talk to juries all the time. And, we tell them they should feel free and open to share. So I think that if they had concerns, I'm sure they had enough time to think about them. But what does bother me, quite frankly, is that on Thursday, when they came in with a verdict and it was unanimous, except when I polled the jury, and then it turned out, no, it wasn't unanimous, but that's very clear in the charge what unanimous is. So, the next thing that surprised me is that they went out and in less than 5 minutes, they were back. It's like, did they really have time to figure out why it wasn't unanimous to begin with? That does concern me, honestly. So obviously, we all want to do what's correct under the Constitution. It's too important. And so ultimately, the decision I make, and I'm sorry, I'm not going to make it today because it is a very important decision. But I think that the way to approach this is more about juror misconduct, not necessarily about the verdict they came up with and whether, that's the real key. Was there juror misconduct? That's the whole thing. If they had these misgivings, but they decided that no, the evidence supported their guilty verdict, then I don't think we have a right to get involved there. So, absent juror misconduct, I don't know that I can overturn their ruling. So, but in fairness, I will consider this. I really don't want to dismiss it so easily because it is a constitutional protection we don't want to take lightly. So that's the best I can do. Now, if you all want to argue it to me now, I'm prepared to hear it. And maybe that will help me decide. But I don't know what else. It sounds like there's not a lot you can argue because of the state's position regarding their objections. So that's probably where we are, right? It's either I sustain the state's objections or overrule them. And I don't know enough about that yet.
Well, Your Honor, I'm happy to make a couple more arguments for the sake of the court.
Yeah.
and your decision making. And of course, if defense would like to add more.
And-
However, a lot of our argument has already been said. I mean, it is the state's position, but we believe it's not just the state's position, it's just the straightforward status of the law that jury deliberations are considered to be almost completely sacred, to the
Right.
point where there can be no inquiry into what was going on in there unless there is evidence. There's a few exceptions, and I may not remember all of them off the top of my head, but the main things are the outside influence on the jury, which there's no evidence of that here. And I believe like explicit racism affecting their verdict can also be an exception to digging into the jury deliberations. But there may be one more other than those two, but there's no exception for, well, we don't think the jurors understood the law perfectly, so therefore we should talk to them, dig into their thinking. Did they follow the law perfectly and come to what we think is a good? That's not, the law is very clear that is not our role. Our role is to explain the law to them during voir dire, to make arguments, to present evidence, and then they get to make their decision. And that's how it works. And there is no opening for digging into their thinking in the jury room to make sure that they were following the law according to our standards. There's just, the law does not allow for that. The law does allow for appealing if, if defense believes that, or state believes that there's grounds for appeal. But I mean, I very firmly believe that there's no legal precedent for what the defense is asking for. And I believe the law is very clear, and their juror misconduct would include that kind of very explicit racism, or them taking outside information or evidence from an outside person that affected their verdict, and there's just no evidence of that whatsoever. So state believes that the law is very clear, and it leads to the outcome that the verdict should absolutely stand. And if defense wants to appeal, then they can appeal.
All right, thank you.
Your Honor, I think the majority of what I have to argue, I've already said. The only thing I would want to add, the state did bring up the case where racism was the issue that the jurors considered. And I don't know if this was part of the case packet that Mr. Lowry presented to the court, but I do have this one as well. It's 137 Supreme Court Reporter 855. It was from 2017, the United States Supreme Court. And Your Honor, that was the case where the state was referring to, where in the case of their phrasing was extreme racism. That is not how I would characterize it. Your Honor, that court states that in certain circumstances, Rule 606, which is the rule that they are arguing prohibits us from discussing anything that happened in that back room, the Supreme Court states that in certain cases, when certain constitutional rights are at issue, that Rule 606 has to give way. Rule 606, as it is written, is an absolute prohibition on any type of statements by the jurors of anything that they considered at all. And what this case, I guess it's Pena Rodriguez v. Colorado. But again, that case I just just referenced from the Supreme Court of the United States, that case says that the 14th Amendment was established because there was a time when we couldn't rely on certain people, certain government institutions to not be racist. We couldn't rely on them to support everyone's equal rights. We had to create the 14th Amendment and hold everyone accountable. And the 14th Amendment serves a higher purpose than a lot of the other amendments, because it is that backbone of equal protection, of equal rights. And in that 14th Amendment is the same thing that states that all these other rights from the Bill of Rights are all imputed to the states. These are all protections that any member of these states all enjoy. Your Honor, this court is saying that Rule 606 is not an absolute rule, that it has to bend at some point. And if they're willing to say that this can bend for the 14th Amendment for racial considerations, it should bend for our other essential constitutional rights. It should bend for our Fifth Amendment rights, if any jurors considered that. It should bend for our right to not be discriminated against based on age, if any jurors were to make a comment about that. It should guarantee all of these rights, again, our due process rights, our right to a fair trial. And so I do think that this Supreme Court case does firmly state that 606 has to bend. 606 is not an inflexible rule. There are certain times where we have to set it aside its prohibition and look at what those jurors considered. And in that case, Your Honor, they take affidavits from every one of those jurors. Every one of those jurors detailed what they talked about, what they considered, because one of the jurors was making was making jokes or was making derogatory statements about the defendant's Hispanic heritage in that case, or one of the witnesses' Hispanic heritage. And Your Honor, the state presents Rule 606 as an inflexible, immovable object that prohibits me from discussing anything that happened in that jury room. There is already one Supreme Court case that says it is not inflexible, that it does bend when constitutional protections are at issue. And Your Honor, I would argue that this is another perfect example of a time when 606 should bend, and the court should consider what was said in that jury room, because it directly abridges Mr. Hiller's due process and fair trial rights that are guaranteed to him by the Fifth and Sixth Amendment, made applicable to the states by the 14th. Thank you, Your Honor.
And Your Honor, I just feel obligated to counter that. That case opens the door, allows Rule 606 to bend, as defense put it, in a specific instance in regards to racism affecting the verdict. And they got all those affidavits, dug into jury deliberations because of the possibility of racism affecting the verdict. If the Supreme Court wanted to create case law saying that you can open the door and get juror testimony and get affidavits on jury deliberations anytime there's concern that the law might not have been followed perfectly, there would be cases that say that. But taking that Supreme Court case and stretching it to say, well, it bends for unconstitutional consideration of racism, so therefore it should bend for a myriad of other reasons, is just simply a wrong reading of the case law. And the truth is that defense's entire assertion that any of the defendant's rights have been violated, there's nothing to back that up, because they need evidence to show that his rights were violated. And there is no evidence that his rights were violated. The fact of the matter is that after you sent them back to deliberate, they returned, gave a guilty verdict, you polled them all, and they reaffirmed the guilty verdict. And neither side can go back there and talk to them and then try to use hearsay, out of court, unsworn statements to try and argue that the defendant's constitutional rights were violated unless it falls under one of the exceptions that's been established. And even then, there has to be some kind of evidence to back it up. And right now, there's no evidence, none, to support what defense is arguing.
Okay. All right, well, I mean, I'm listening to both of you all, and I'll be honest, I am inclined to just live with the verdict that was given by the jury, because I think that there's other ways to address this. I don't think that I want to challenge the verdict they gave under oath in court. I think that would be a misapplication of the law. I mean, because when they were polled, they were still under oath. So I do want to read everything, though, just on the off chance that there's something there persuasive that is important enough to rule against the jury. But that's not what I'm going to be looking for. It's just if it's there, then I will consider it and weigh it. Okay, but that's the best I can do. I just, the fact that they came in even so soon after giving a not guilty, I just, they are the judges of the facts. And if they came back and under oath said, no, my verdict is guilty, well, I don't know that I have a basis to challenge them. And you know, it's unfair, but jury trials are still the most important tool for getting at the truth. So all I can do is apply the law, and I can say that perhaps when you all do voir dire, you need to make sure. I mean, I've been in some voir dires where they say, if you decide one way, are you going to let somebody else change your mind? You know, because there is some kind of social pressure involved sometimes, but they have taken an oath to, you know, make their rulings the way they do. And so if they're violating that oath, that's something else. But I do want to read everything and just be sure I'm not overlooking something. This is a very new experience to me. So I will keep an open mind. Okay, that's best I can do. Okay.
Thank you, Judge.
All right. Thank you all very much. Okay, we are done, aren't we? We don't have another